Today we're going to review contract law, especially with regard to contract performance. I'm going to briefly give some background on contract formation and a little preview of contract remedies before focusing on contract performance. And by the way, I have a separate video on contract interpretation where I get into much more detail on that topic. Today we'll focus on a contract which is formed and reasonably understood, and the question will be whether it is performed. Contract law is divisible into three large parts. First, formation, which deals with the creation of enforceable obligations through an exchange of promises. Second, performance, which deals with whether those obligations are met. And three, remedies, which deals with parties' liabilities when contractual obligations are not met. Today's review will focus on contract performance. After a very brief review of contract formation and preview of remedies, for the rest of the review, we assume a contract exists. That is, there are enforceable promises that need to be performed. Contract formation requires an offer, which will state the terms and conditions of an agreement, and acceptance by the offeree of the terms of that offer. Any change in those terms may result not in acceptance but a counteroffer. In addition, the contract must include something special called consideration, which effectively means that there is a bargain for exchange such that both parties are getting something they want in this contract. There are some exceptions in equity to the doctrine of consideration, such as promissory estoppel and promissory restitution, where a contract can be enforceable without consideration, but those are equitable exceptions. The statute of frauds finds a contract unenforceable in certain cases where it doesn't have a signed writing, and there are defenses that say contracts are not formed in a variety of instances, such as mistake, misrepresentation, undue influence, duress, unconscionability, etc. We can visualize a formed contract with the illustration on the screen. A typical contract includes a promise in exchange for the consideration. This is also known as an exchange of promises. As the image illustrates, most contracts are formed by a mutual exchange of promises. We'll come back to this image later where we add the dimension of conditions upon the promises. Contract performance can be broken down into four discrete elements. First, interpretation of the contract, which relates to the meaning of the enforceable agreement. We have to determine what the parties intended their agreement to mean in order to establish whether or not they met those obligations. One of the most important things to interpret is whether a promissory term is a condition or an actual promise, or both. So conditions are part of the interpretation process as we determine whether parties intended there to be an express or implied condition to a promise, which has to occur before that performance is due. Then we would analyze whether or not there is performance or whether there has been a breach. And when we're dealing with express conditions, this is a pretty simple binary. Either there was complete performance or there wasn't. But more fundamentally to our study is the doctrine of substantial performance, which the doctrine of substantial performance holds that when parties have implied that one person's conduct is a condition precedent to the obligation of the other, that conduct needs only be substantially performed. And this will lead us into an analysis about repudiation, because parties might believe that they are entitled to terminate a contract even when they're not. And so the concepts of performance and substantial performance and whether the other party has the right to terminate the contract or whether attempting to terminate the contract would constitute a repudiation is our third category of concepts that I've listed as performance and breach. And then we have some defenses. Sometimes courts will not require a party to perform even when performance is due. These are fairly exceptional, and we'll take a look at those exceptions. Whenever performance of a contractual promise is due, any non-performance is a breach. and any breach can give rise to liability for remedies, including damages. Damages are financial awards that a court will require one party to pay the other. Damages are most commonly measured by a party's expectation interest, which is how much a party expected to benefit from a bargain versus how much benefit was actually received. In other words, expectation damages put the non-breaching party in the position it would have been in had the contract been completely performed. When expectation damages cannot be calculated with reasonable certainty, a court may instead award reliance damages, which put the non-breaching party back in the position it would have been if the contract had never been formed. When justice requires, courts may require a payment of restitution, which is an unusual remedy, in that the breaching party, and not just the non-breaching party, may be entitled to an award of restitution. In rare cases, courts will require specific performance, which is where a court requires a party to actually do or not do something other than to pay money. For example, an injunction may prohibit a former employee from working for a competitor. This review will not address remedies in detail. For present purposes, the key thing to remember is that any breach of a contract may lead to liability for damages or another remedy. A preliminary step to analyzing contract performance is to interpret what the contract says. The key point in contract interpretation is to arrive at the meaning that the parties intended when they entered into the agreement. In other words, the meaning that the parties ascribed at the time of formation is what's relevant. Courts will determine the meaning of a contract from 7 different sources. The first is the contract itself, and we're going to apply the canons of construction, which are rules that govern how we interpret writings and oral agreements, to determine what the parties meant when they executed a document or made an oral agreement. The contract may also include express references, maybe to statutes or to other contracts in the past, and those will be considered as part and parcel of the bargain as well. And courts will overlay this with their own common sense and make sure that the contract is read in a way which is sensible to a reasonable person. We're also going to look at what the parties did under this agreement as informing what the parties meant when they formed the agreement, and this is called course of performance. Course of dealing is what the parties did under a different agreement, so it's slightly less relevant to our current contract, but since we're dealing with the same parties, it still has some relevance. It could tell us what they intended. Trade usage can be very relevant in determining what parties meant when they're both part of a trade and might be presumed to have a common understanding based on the nature of the meaning of those terms in a trade. Of course, if the parties are not part of a trade, trade usage would not apply because it wouldn't show anything about what they intended or what they actually thought. Last and probably least is preliminary negotiations. When parties have negotiated on a certain point, and that point is not memorialized in a signed writing, we should be very skeptical about whether the parties intended those negotiations to become their contract terms. And this would lead us to an analysis known as the parole evidence rule. The first category of sources of meaning of a contract are known as intrinsic evidence. They are within the 4 corners of the contract. Obviously, the writing itself is within the 4 corners, but express references to specific statutes and other contracts are also brought into the intrinsic evidence. And we say that a court's common sense is a review of the intrinsic evidence, even though obviously that common sense is informed by outside dealings. This is to be distinguished from extrinsic evidence, which would be things that the parties said and did and the circumstances that they found themselves in, but nothing that was actually written down or referred to in the writing. And one type of extrinsic evidence which we should be very skeptical about including is called parole evidence. Parole evidence is evidence of extrinsic conversations that were prior or contemporaneous with the contract, but were not memorialized in the contract. And that would lead us to an analysis called the parole evidence rule. For a further review of contract interpretation, check out the video that I have on YouTube for more information about the entire parole evidence rule and the other contract interpretation elements. The part of contract interpretation which is most relevant to performance, at least most simplistically relevant to performance, is evaluating, based on our contract interpretation, whether a term is a promise or a condition. It's a critical step because a promise creates an obligation, whereas a condition triggers an obligation, makes an obligation come due. And a look at the definitions and types of each should make this distinction clearer. The Restatement Second of Contract, Section 2, Sub 1 says, "A promise is a manifestation of intention to act or refrain from acting in a specified way, so made as to justify a promisee in understanding that a commitment has been made." In other words, when parties make a promise, this is something that they have to do. All contractual promises must be performed. It's a bit of a circular definition, but by calling it a promise, an enforceable promise, we say that it is something that courts will enforce. However, it may not be ripe or due or time for that performance yet. Contractual promises may be subject to conditions such that the promise is not yet due if the condition has not occurred. Conditions are events that impact whether contractual performance is due, and so they have a great deal of bearing on contract performance. There are three types of conditions: conditions precedent, conditions concurrent, and conditions subsequent. A condition precedent is created either expressly or implicitly by sequential dependent promises. In other words, where we have a promise, the exchange of which is a promise that, for example, work for money. And you have to do work over a period of time with the expectation of receiving money. We might imply that these promises are sequentially dependent, and they therefore create a condition precedent. A condition precedent must occur before another obligation comes due. And we say precedent because it happens earlier in time. Very typical to find these types of conditions precedents and to imply them in work for hire agreements. For example, I'll pay you $10,000 when you complete building my garage. Building the garage has to occur over time. And when that performance is complete, only then is the obligation to pay due. So a condition precedent may be implied where one of the contractual promises needs to occur over a period of time and would reasonably be a condition precedent to a further obligation, such as you do the work before you get paid. A condition concurrent can arise where we have mutual and simultaneous promises. For example, if I were to say to you, let's exchange $10,000 for my car on Tuesday at noon. These are two things that can, and under a reasonable understanding of the parties' intentions, should happen at the same time. And in fact, this is the default assumption. We assume that promises in an exchange of promises, a standard contract, is a mutual and simultaneous agreement. So our default state is that we're actually going to assume that the parties have implied that their promises are concurrent conditions to each other. The exceptions to this are, first, where the work needs to be performed over time. We dealt with that with conditions precedent. And there may be some unusual cases where the parties made promises that are truly independent from each other. But this is the default under law. We assume that when parties enter into a bargain, one party's performance is implicitly a condition concurrent to the other and vice versa. They are both conditions to each other. And the pause symbol here doesn't just represent a period in time, an instant in time where both things happen, But if you turn that sideways, it's an equals. The parties have equal obligations to each other, and that's where we get the concept of mutuality. The third form is called a condition subsequent, and quite frankly, this doesn't come up all that often in contract law. It comes up much more often referring to rights in land, and conditions subsequent are going to be something that tend to be more relevant on your property exam than on your contracts exam. They have to do with things like a future interest or a right of reentry and the ability to recover possession and title. But they don't come up terribly often in contract law per se. More relevant to our discussion are conditions precedent and conditions concurrent. The formal definition of a condition is found in Restatement Section 224. A condition is an event not certain to occur, which must occur, unless its non-occurrence is excused before performance under a contract comes due. So a couple things to briefly note about this definition. First, we have to have some type of event, and that event must be uncertain. So the passage of time we consider a certainty. We say that the sun will rise tomorrow with some relative certainty. We're looking for something more uncertain than that, like whether or not the car is clean when it is to be delivered. The event is the car being clean or being cleaned. That may or may not happen, unlike the passage of time, which we assume is going to occur. We can redraw our image of consideration as follows. A promise is exchanged for consideration, but that promise is not due. The performance of that promise is not yet owed until a condition occurs. And in this particular diagram, we would say there is a condition upon the promise, meaning that that promise does not need to be performed. The duty to perform that promise is not due until the condition has actually occurred. And by the way, sometimes the condition is something the other party needs to do, and sometimes it's a third party who needs to perform the condition, or it could just be an event. It could be something as straightforward as, if it rains on Tuesday, then I will sell you an umbrella. If it doesn't rain on Tuesday, I have no obligation to sell you the umbrella, even though neither party had a responsibility for bringing about that condition. However, the condition might also be based on the contractual obligations. So if I say, I will exchange my car for $10,000 with you on Tuesday, I have an obligation to bring my car to the designated spot. If I fail in that, you don't have an obligation to pay me. So the condition can arise either from an obligation of one party, also known as a promissory condition, or a future and uncertain event that has nothing to do with the parties. There are two types of conditions, and it matters a great deal which one we have in terms of whether or not performance of the other party is due. I'll first deal with express conditions because they're a bit simpler. Express conditions require complete performance in order to be fulfilled. And I'll give you an example of an express condition in just a moment. But express in all of contracts means explicitly written or said. So we have to actually find, if we have a contract, we're looking for the contract to have something written which appears to be a condition, or the parties in an oral agreement have said something which is going to be reasonably interpreted as a condition, as opposed to an implied condition, which is something that arises from the circumstances, not from something the parties actually said and did. Here's an illustration of an express condition. A contracts to sell and B to buy goods pursuant to a writing, and the writing says, under a heading, conditions of sale, that the obligation of the parties are conditional on B obtaining from X bank by June 30 a letter of credit on stated terms. We're going to need to find pretty clear language. Are conditional upon, are subject to, shall only be required if. Language like this is going to show there is an express condition, and it's helpful if they're in a section of the contract called conditions. But again, express conditions must be written or said by the parties in the process of forming a contract. And moreover, they require complete performance. So again, an express condition is a condition that is explicitly stated in a written instrument or in an oral agreement. And it's a contractual condition that usually, in the context you'll see it, parties have reduced to writing. When this occurs, we require complete performance. Otherwise, the other party's obligations, which are subject to that condition, will not come due. Nothing less than complete performance will activate a duty pursuant to an express condition. There is a flavor of conditions called promissory conditions because a term can be both a promise and a condition. In fact, this is often the case when we have mutual dependent conditions. And we saw this in the case of International Rotterdam, but they occur quite frequently. There's another flavor of conditions called conditions of satisfaction. And a condition of satisfaction is one type of express condition where one party's performance is due only when it is satisfied. Satisfaction may sound subjective, but we can apply, in some cases, a reasonable person standard to whether or not satisfaction would be reasonable under circumstances. And we prefer that because it allows for less gaming of the system. And so we have a preference for an objective standard of satisfaction, provided that the circumstances permit it. And conditions of satisfaction are also subject, as are all terms in a contract, to the duty of good faith and fair dealing. Which means that if you are actually satisfied, you can't lie and say you're not satisfied, even if we're interpreting a condition subjectively. You have to be honest and act with good faith and in fair dealing in all your contractual obligations, including conditions and conditions of satisfaction. Now, I told you that a promise subject to a condition is not due until the condition occurs. That's mostly true. In addition, a court can excuse a condition, and that has the same effect as the condition having occurred. So we can excuse a condition because if a condition does not occur, and again, it has to completely occur. So if an express condition does not completely occur, then the other party has no obligation to perform, which can result in forfeiture. So if there is an express condition that says, I will pay you $10,000 for the car if it is clean, and it has one speck of dirt on it, I don't have to pay for it at all as a technical matter. But courts have the doctrine of condition excuse to ameliorate the forfeiture that can otherwise result. The way the restatement, section 229, words it, I find a bit confusing, so I've reworded it here for you. A court may, and this is important because this is an equitable doctrine, it's not something you can stand on as a matter of law, so you have to make an argument that it's merited. What may the court do? It may excuse the non-occurrence of a condition. In other words, it can act like that condition occurred. And when can it do this? When can it treat the non-occurrence of a condition as if the condition really occurred? When the non-occurrence would cause disproportionate forfeiture. When one party would be harmed in a great way, much out of balance with how much the other party would be harmed if the contract were simply upheld. Again, an equitable doctrine. And it has a limitation unless the occurrence was a material part of the agreed exchange. If the occurrence was what the bargain was, the court should not have the right to waive it. That would interfere with the party's intentions. A party may also waive a condition. You can think of conditions as a sort of property interest or right that a party has. It's your condition, and you have the right to exercise it or waive it at your discretion, kind of like an ace up your sleeve. A party may waive the non-occurrence of a condition, and by waiving the non-occurrence of a condition that would obligate you to perform, you can actually create an obligation in yourself. Now, of course, you cannot waive the other party's conditions, but if you hold the condition, you have the right to use it or lose it, and you can lose it by waiving it, which can happen either expressly or implicitly. Conditions are not only expressed by the parties, however. Conditions can also be implied by courts. In the process of contract interpretation, we're going to look at the express language, but we also are going to look at the circumstances, and in many cases we will find that the circumstances imply that the promises were conditions concurrent to each other, or that one promise was a condition precedent to each other. In fact, the default assumption is that contracts usually imply an exchange of promises. In other words, courts assume that parties intend mutual promises to be connected to each other. A condition contained in an essential contract term, although omitted from the parties, can be supplied by the court. This is to do justice and is called a constructive condition and is subject to some more complex rules than express conditions. Notably, implied conditions are subject to the doctrine of substantial performance. While implied conditions are different from express conditions in a very important way. Implied conditions are different from express conditions in a very important way. While express conditions must be completely performed in order for the performance subject to that condition to be due, implied conditions need only be substantially performed. And the doctrine of substantial performance was first introduced by Justice Cardozo in Jacobs and Young v. Kent, a famous opinion. The concept of implied conditions dates back to at least 1773, when Lord Mansfield categorized covenants, what we would call promises, into three types, each related to certain assumptions about implied conditions. The first type are independent promises. When we find that parties have made independent promises, this means that we have promises in a contract which are unrelated to each other, even though they're part of the same agreement. Courts will find independent promises only infrequently. It's actually fairly uncommon for one contract to include two obligations that have nothing to do with each other, but when this occurs, we find there are no implied conditions. Both of the promises need to be performed regardless of whether either is performed. Neither party's performance triggers or extinguishes the other party's duties. It's almost as if we have two completely separate agreements. That's the meaning of an independent promise, but it's actually not very common. More common are dependent sequential promises, which is a fancy way of saying that one thing happens before another. They are both related to each other, but one is going to always happen first in time. And this is actually quite common. Dependent sequential promises will imply conditions precedent, that the first thing has to happen before the second thing is required to occur. This is very common where one does work over a period of time in exchange for payment in the end. The work is probably going to be interpreted as condition precedent to the payment. In other words, you don't get paid until you finish the job. This is a common understanding of how parties actually intend their contracts to work. And in these cases, completing the work is going to be an implied condition precedent from the duty to pay. According to the doctrine of substantial performance, the work does not need to be completely performed to trigger the duty. Substantial performance of the work triggers the duty to pay for it. However, the worker is still liable for breach and damages to the extent that the work is incomplete, but has a right to payment. The third and most common are dependent simultaneous or mutual promises. Dependent simultaneous or mutual simultaneous promises are where the parties intended each other's performance to occur at the same time. This is exceedingly common, especially in transactions of sales. One party agrees to pay for goods, one party agrees to provide the goods, and those two things are meant to happen at the same time. The proverb is cash on the barrelhead. You put the cash down and you simultaneously exchange the payment for the goods that you're purchasing. And this leads to an implication of conditions concurrent. Conditions concurrent and equal so that they both have to occur to trigger the other's duty to perform. Either party's performance triggers the other's duty to perform. If neither party performs, it's not usually a breach, but if one party was ready to perform, and the other party neglected or refused to perform, the other party, who is not prepared to perform, has breached. These are sometimes called the Kingston Covenants, but they have been established in the Restatement Second of Contracts and are well understood in all jurisdictions today. The so-called Kingston Covenants, as articulated in 1773 by Lord Mansfield, have been adopted by the Restatement Second of Contracts, in which Section 231 sets forth the rule for determining whether promises are independent or dependent. Performances are to be exchanged under an exchange of promises if each promise is at least part of the consideration for the other, and the performance of each promise is to be exchanged at least in part for the performance of the other. This language is not particularly clear, but what the restatement is getting at is that it is relatively easy and in fact very common to find that promises are given under an exchange of promises such that one is the condition for the other and potentially both are conditions to each other. Section 232 goes on to describe when, and it is frequently, when it is presumed that performances are to be exchanged under an exchange of promises. This is our default assumption. We actually assume in most contracts that the promises are dependent on each other. Where the consideration given by each party to a contract consists in whole or in part of promises, all the performance to be rendered by each party are taken collectively, are treated as performances to be exchanged under an exchange of promises unless a contrary intention is clearly manifested. In other words, we are going to presume that promises under a particular contract are mutual and dependent upon one another. Restatement Section 234 elaborates on 232's presumption for dependent promises by further stating a preference for finding simultaneous promises and therefore implied conditions concurrent, where all or a part of the performances to be exchanged under an exchange of promises can be rendered simultaneously. They are, to that extent, due simultaneously, unless the language of the circumstances indicate to the contrary. Once again, we see that the restatement has a preference for conditions, promises being conditions to each other, and in fact, those conditions being mutual and equal obligation. Although the restatement suggests a preference for finding that promises are mutual to perform simultaneously, it also provides plenty of room for finding that promises are intended to be sequential. In fact, the preference shifts to finding for dependent sequential promises where performance can only be completed over time. In these cases, the performance that must be completed over time is a condition precedent to the other contractual obligations, where the performance of only one party under such an exchange requires a period of time. His performance is due at an earlier time than that of the other party, unless the language or the circumstances indicate the contrary. Again, a very strong preference for finding that promises to a contract are not independent, and they are generally, if not almost always, either mutually dependent as concurrent promises and concurrent conditions, or sequentially dependent as condition precedent to one another. This was clarified and elaborated in the famous decision of Jacobs and Young v. Kent, where Justice Cardozo discussed how conditions may lead to unfair results such as forfeiture, and he, at that point, articulated the doctrine of substantial performance, which I'll next cover. And essentially, the substantial performance doctrine states implied conditions need only be substantially performed in order for the return performance to come due. We don't need complete performance of an implied condition. The doctrine of substantial performance, which essentially states that implied conditions need only be substantially performed in order for a dependent performance to come due, creates a spectrum of performance and breach. First is complete performance, also known as exact performance. This is the full performance of obligations as detailed in the contract. Second is substantial performance, which is performance of the primary, necessary terms of an agreement. Third is material breach, also known as defective performance, which is performance that, whether partial or full, does not comply with the contract, such that the party did not receive the benefit of the bargain. Fourth is total breach, also referred to as non-performance, and this is the utter failure and an irredeemable failure to discharge a contractual obligation. Let's compare the status of these four elements on the spectrum of performance with their effect, and in the process review the effect of performance and breach. Complete performance is the successful completion of a contractual duty. It releases the performer from any liability. It discharges the performer's duty. It also triggers the other party's obligations to perform under an exchange of promises. Substantial performance is a good faith attempt to perform that doesn't precisely meet the terms of an agreement, but the essential or primary purpose of the promise is accomplished. The substantially performing party is still liable for its shortfall because any non-performance is a breach, but the other party must now perform its obligation under the exchange of promises. Again, we're talking about sequential performance, so usually this means the work was good enough that the worker has the right to get paid. Material breach is a defective performance where the primary purpose of a promise was not achieved. The aggrieved party can withhold its performance while the breaching party has a time, known as a cure period, to cure or remedy or overcome the breach. The breaching party is, of course, still liable for damages for its shortfall. Fourth, total breach occurs when the cure period for material breach has expired. The material breach is a temporary state. It will either be cured and therefore result in substantial performance such that the worker gets paid, or it will expire, the cure period will expire, and we will be in total breach where the aggrieved party gets the right to terminate the contract and find someone else to do the work. This chart gives you an overview of the different status of performance and breach and its effect on contractual obligations based on whether we have independent promises, which are very rare, mutual and simultaneous promises, which are extremely common, and sequential dependent promises, which are the second most common and occur when one performance must occur over a period of time. Distinguishing between substantial performance and material breach requires a five-part analysis that's articulated in section 241 of the Restatement Second of Contracts. It's effectively a balancing test with the following factors. On the one hand, we look at the obligee, which is the person who was to receive the particular benefit of the bargain at issue, how much they were deprived. Did they receive some of the benefit they expected? Most of the benefit? None of the benefit? So the first factor is the extent of the obligee's deprivation. The greater the deprivation of the benefit, the more likely we have a material breach. Offsetting that is the obligor who will suffer a forfeiture of some extent if we determine there is a material breach. If there is a material breach, the obligor will not get paid for the work, and that can represent a forfeiture. If the obligor has been paid for 90% of the work, has been paid 90% of the contract value, we would probably find little or no forfeiture. On the other hand, if the party has completely or almost completely performed its obligations and has not been paid at all, there's a great deal of forfeiture from finding a material breach. The greater the extent of the forfeiture, the less likely we are going to find material breach, which would cause that forfeiture to occur. Moving back to the other side of the ledger are the obligee's remedies at law. We're asking whether the obligee has an ability to win damages in court or cause the contract to come due. If the if the obligee has the ability to get the benefit of the bargain through the legal system, we are probably going to find there is substantial performance, or that is going to weigh in favor of finding for substantial performance, because the obligee can pay the obligor and then sue and be made whole. On the other hand, if we declared a material breach, that gives the obligee the ability to withhold payment and in that way potentially force the obligor to complete performance, or at least to engage in self-help. So the greater the availability of remedies at law are to the obligee, the less likely we are going to find material breach. Fourth is the obligor's likelihood of cure. The greater the obligor is expressing his or her willingness to cure, the less we have the need to declare this a material breach. In other words, if the obligor is expressing a great deal of willingness to fix the problem, we don't have the need to not pay the worker. If the worker is going to repair the work because they are acting in good faith, then allow the worker to be paid and to complete the work. On the other hand, if the obligor is walking off the job or refusing to repair damage, we are more likely to call that a material breach and give the obligee the ability to engage in self-help. And on top of all this is the obligations of both parties to engage in the contract in good faith. If one party or the other is not acting in good faith, we're going to tend to rule against that party. Remember that the obligor wants there to be substantial performance, so the obligor gets paid. In other words, the obligor wants the court to say, you have done enough to merit payment. And so the obligor's good faith would be a factor towards substantial performance, and the obligor's bad faith would be a factor toward material breach. And the obligee is the inverse of that. The obligee is looking for a material breach so that it doesn't have to pay. If the obligee is doing this in bad faith, we are less likely to award material breach to the obligee, who is seeking the material breach award so that the obligee does not have to pay. This is a balancing test, and no one factor outweighs the other, and it's really a question of analyzing all of the facts and circumstances to evaluate whether this tips in favor of substantial performance for the obligor or material breach, which benefits the obligee. If we are in material breach, we are not done with the contract yet. Material breach simply means that the obligee has the right to withhold payment for a reasonable time, and this time is known as a cure period. During the cure period, the party in material breach has an opportunity to elevate their performance back to a level of substantial performance. However, at the extent and the end of the cure period, the failure to cure will cause that material breach to become a total breach. Whether or not material breach has matured into total breach requires an analysis first of the 5 factors in Section 241 plus 2 additional factors in Section 242 with regards to timing. Notice that both Section 242 factors have to do with whether delay is going to cause a problem. And this makes a great deal of sense when the question is, has time run out? What we're basically evaluating when distinguishing material breach from total breach is whether the obligor still has time to meet the obligation. And the factors that relate to whether an obligor has the time to meet an obligation have to deal with whether delay is going to cause more harm and whether the agreement provides that time is of the essence. Repudiation is defined as the refusal to perform a contractual duty before the time for performance is due. And this would occur when a promisor, or we might say an obligor, unequivocally disavows any intention to perform when the time comes. It's also known as renunciation. Those are synonyms. And this ties in with the doctrine of substantial performance because a party might feel that it has the right to terminate a contract when it's wrong. The party might mistakenly think that its counterparty is in total breach when it's not yet in total breach. Then the party who is quote-unquote terminating the contract is really repudiating the contract and has itself breached the deal. To put this in another way, Termination and repudiation are two different characterizations of the same action. Termination is a justified legal action where a party says it is not going to perform its obligations, whereas repudiation is an unjustified or wrongful declaration of a refusal to perform. Remember, a total breach by one party means that the other party has the right to terminate the contract. When one party is deciding whether or not it has this right to terminate, it doesn't have, in most cases, the benefit of a court order or a declaratory judgment finding a total breach. Instead, a party's lawyer, maybe you someday, must critically analyze the situation and determine whether the client has the right to terminate the contract or whether the breaching party still has time to cure. If a party purports to terminate a contract when the other party is not yet in total breach, then the terminating party has actually repudiated and therefore has itself committed a wrongful breach. Repudiation is a term of art that implies wrongfulness. It is more precise to refer to the refusal to perform an obligation where performance is due as repudiation, but we use it specifically as wrongful repudiation or unjustified repudiation, where that refusal to perform an obligation is not as the result of the other party's total breach and is therefore wrongful. This also comes up when one party wants to withhold payment, but it believes the other party has materially breached. If the other party has materially breached, then yes, there is a right to withhold payment. But if the other party has substantially performed, then the non-paying party who is withholding payment is now the one who itself is in breach. The repudiation has the effect of a total breach, and it would give the other party then the immediate right to terminate the contract and sue for damages. So again, it's very important before telling your counterparty you're not going to perform and the contract is canceled, that you're either prepared to accept the damages that will be incurred by you breaching, or you have a great deal of confidence that your counterparty is in total breach. Repudiation can be express or implied. It can be made using clear, unequivocal words and actions, or it can be shown by an unwillingness to perform as promised. When it is expressed, we need statements or actions that positively mean the other party cannot or will not perform. The mere expression of doubt or of questions about willingness or ability to perform is not enough. We need something unequivocal. An unequivocal express repudiation is needed in order for it to be effective. So a party may not feel comfortable declaring a contract terminated just because it's not sure that the other party is going to perform. Instead, the party has a different right. While a party doesn't have the right to terminate a contract just because it's not sure the other party will perform, this insecurity can give rise to the right to demand assurances. Restatement section 251 Sub 1 states, where there are reasonable grounds arise to believe that the obligor will commit a breach by non-performance that would of itself give the obligee a claim for damages for total breach under section 243, the obligee may demand adequate assurance of due performance and may, if reasonable, suspend any performance for which he has not already received the agreed exchange until he receives such assurance. So a party may not have the right to terminate a contract because they're unsure, but they gain the right to demand adequate assurances. Being in a state of demanding adequate assurances is similar to being in a state of material breach. In both of these states, one party has the right to withhold performance, while the other party has a reasonable time to cure any defects. The difference is that the right to demand assurances arises before the time for performance is due and requires reasonable grounds to believe a total breach will not occur, whereas the right to withhold performance arises after the time for performance is due and performance has not been substantial. And we see that in section 251. It goes on to say that the obligee may treat as a repudiation the obligor's failure to provide within a reasonable time such assurance of due performance as is adequate in the circumstances of the particular case. In other words, if a party is reasonably uncertain and demands assurances, the other party has a period of time, similar to a cure period, to make those assurances. And if those assurances do not occur within a reasonable time or are inadequate, we can treat the failure to provide assurances as if it were a repudiation, which has the function of a total breach. At the beginning of this discussion, I said contractual promises must be performed when the time for performance comes due. That's true, of course, unless performance is for some reason excused by a court. Excuse can happen for several reasons, and in general, the buyer and the seller in a contract will have different reasons for seeking excuse. The seller or provider of services may claim that she, he, or it is unable to perform because some event has rendered that performance impossible, or at least impracticable. Examples include promising to rent out a music hall, and then the music hall burns down. But courts must be careful not to grant such sellers' excuses too easily. For example, under a contract to weekly mow a lawn during the summer, what if the lawnmower breaks? Is the landscaper therefore excused from further performance? Well, no. The landscaper could purchase another lawnmower. It may cost him a bit more to do so, but he is still able to perform. On the buyer's side, excuse is usually sought where the object of the contract is no longer needed. For example, an Englishman rented a room to watch the coronation of King Edward VII, but the coronation was unexpectedly postponed, and the court determined the man did not need to pay for the room, as his purpose for using it was frustrated. But courts must be even more careful not to grant buyers' excuse too easily, because these scenarios are all too common. If excuse were granted readily, it would eviscerate contractual duties. For example, a landowner orders catered food for an outdoor party on her estate. But on the scheduled date for the event, it's raining. Should the landowner still have to pay the caterer? Well, yes, because rain canceling an outdoor party is a reasonably expected event, and the landowner should bear the risk and not the caterer. The caterer has its own risks to worry about, for example, an increased price in food ingredients. Just as we would not let the caterer out of a contract because chicken breast became more expensive, the landowner shouldn't be excused just because the party is rained out. The excuse doctrines are all about who bears the risk of a loss. Courts must allocate risk where parties haven't done so, and they are rightfully hesitant to excuse parties from contractual obligations. Otherwise, the essential purpose of contracts as enforceable obligations would be undermined. That said, the doctrine of impracticability does grant a party an out from a contract where that party is not going to be required to perform if these elements are met. We can find the elements in the restatement, but I've broken them down a little bit differently here. The first is that we need an event to occur. An event that occurs after the contract was made, and, moreover, not by the fault of a given party. The event must make performance impracticable. Now, impracticable is a term of art, and defining it takes a little bit of work. It is something less than impossible, but yet very difficult to do. The only way to really understand the impracticability doctrine is to make analogies to the various cases where impracticability was found or not found. For example, in cases where one party had to pay 30% more for the shipment of goods, we determined it was not impracticable. But in another case where the cost of performance was increased by 10 to 12 times, or 1,000 to 1,200%, a court did find that performance was impracticable. It's a very fact-specific inquiry, but it requires a great deal of financial burden. Or More relevant for our times, impracticability may be found where health and wellness is potentially negatively impacted by contract performance. And so for public policy reasons, courts might excuse performance. The non-occurrence of the event must be a basic assumption of the contract. And we saw this in the case of Surrey Music Hall. The continued existence of Surrey Music Hall was an assumption in the contract for the rental of the music hall. And so we have the element that the non-occurrence of the event has to be a basic assumption on which the contract was made. And we also have the element that the contract does not allocate the risk of this event to a particular party. Again, the excuse doctrines are asking courts to allocate the risk of loss to one party or another. If the parties have already allocated this among themselves, a court should not interfere. There are three common scenarios where impracticability, or for that matter impossibility, is often found by courts. First, when a person who is necessary for performance dies. And this really means that the person who is performing is somehow special. The restatement gives an example of a confidential secretary who dies. You might also think of a celebrity or performer. If you hire Lady Gaga to play a show and she is incapacitated, the show cannot go on. And that would make performance impracticable. Similar is destruction of a necessary thing, like the Surrey Music Hall. And in that case, it was really all about renting that particular venue, and so when it burned down, the contract could not be performed. And again, relevant for our time is prevention by a regulation or governmental order. So you may have hired someone to come out and repair your roof. And the Governor Wolf said that no homework can be provided, in which case that person who is meant to repair your roof would be excused. And that is true even if as a result your house gets wet. You cannot sue that roofer because his ability to perform was prevented by Governor Wolf's order. And so those are the three most common scenarios. And notice that none of them have to do with finances. It's actually going to be much less common where courts grant excuse simply because something got expensive. And the effect of this excuse is we're going to discharge a duty and tell a party they no longer have to perform. The flip side of the impracticability defense is the frustration of purpose defense. And as we go through the elements, I hope you'll see why the frustration of purpose is usually sought by a buyer, whereas impracticability is usually sought by a seller. How are these elements different? Well, they're actually mostly the same. The first is the exact same thing. An event occurs after the contract was made and without the fault of the party seeking excuse. The second element is a bit different. The second element of frustration of purpose, the event makes performance substantially frustrated. Now, what exactly does substantially frustrated mean? Well, we have again to look at case law to see where this happens, but it happens very infrequently because generally a party bears the risk of loss for an event not happening. The third element is that non-occurrence of the event is a basic assumption of the contract, and of course the contract, once again, cannot allocate the risk of this happening to one party or to the other. The effect of frustration of purpose is once again to discharge the duty. There is a distinction between a supervening and an existing impracticability, and the restatement provides excuse in both cases. A supervening impracticability is where the event occurs after the time of formation and before the time for performance, hence supervening. It is in the middle. Existing impracticability and frustration of purpose, however, means the event actually happened before the contract was made. And this provides for a very unusual fact pattern. The examples for this would be something like there is a contract to buy and to sell a very particular painting, which is located in a warehouse maintained by a third party. And as the contract is being formed and unknown to the owner and the seller and the buyer of the painting, that warehouse is burning down. And it would be not possible to be informed about this. So the event happened before formation, but the parties were not aware that it occurred. This slide shows the difference between the supervening and existing impracticability and frustration of purpose doctrines. The first distinction should be pretty clear. It has to do with the time at which the event occurs. In the case of supervening impracticability and frustration, the event occurs after the contract was made, whereas existing impracticability looks at something which is true at the time of formation. In both cases, the event must not be the fault of the party seeking the defense. In addition, we add with existing frustration and impracticability that the person seeking the defense would have no reason to know that this event occurred. And the other difference is that in the case of impracticability, supervening impracticability and frustration of purpose, in the case of these supervening events, a party may have already performed, but in the case of existing impracticability, we say that no duty arises because, in fact, this would have defeated the purpose of the contract at the time it was made. But really, if you look at these, there's not a whole bunch of difference, at least in the law, between them. The key thing that defines the difference between supervening and existing impracticability and frustration is that the existing impracticability or frustration has the added element that the parties must not have known about this at the time the contract was formed. As I mentioned, courts don't grant excuse very often, and it would take more than a small amount of cost increase to drive the court to this decision. We are going to find excuse doctrine granted the most frequently in cases involving health and safety. And in this time of COVID-19, we might expect courts to be very willing to grant excuse where a particular contractual promise, the performance of which would jeopardize health and safety. And for that matter, a lot of activities subject to contracts have been rendered impossible, or at least illegal, and therefore impracticable by Governor Wolf's order. In addition, there are cases that show a huge increase in cost may result in a excuse being available. But we're talking about a 10 times, 12 times increase in cost, not a few percent points. And when the purpose of the contract ceases to exist, we sometimes will grant frustration of purpose, just as we did in Taylor versus Caldwell. In conclusion, contract performance is the middle of three analytical stages. It's analyzed after it is determined that parties have a contract, and before assessing to what extent one party owes remedies or damages to the other. The first step in the analysis is to determine the meaning of the contract itself, and this process is called contract interpretation. One critical aspect of contract interpretation is determining whether a term is a promise or a condition. This distinction has a significant impact on contract performance because performance is not due until all the conditions have occurred. Evaluating performance and breach as a dichotomy is easy. Any failure to completely perform all the promises in a contract is a breach. However, the doctrine of substantial performance complicates things. Under the doctrine of substantial performance, any party's performance may be subject to an implied condition, and this is going to come due, or this condition can be met and satisfied where a party has substantially performed its obligations. In other words, something less than full performance can trigger an obligation that is subject to an implied condition. If a party has not substantially performed, but instead materially breached, then the other party has the right to withhold performance for a reasonable time, called a cure period. And when that cure period has expired, the breaching party has totally breached, and the non-breaching party may terminate the contract. There aren't clear lines between substantial performance and material breach. Instead, we have a 5-factor test. Nor is there a clear line between material breach and total breach. There we add 2 additional factors to our balancing test. But the key thing is effectively whether the essential purpose of the contract was fulfilled and whether or not we should allow time for cure. If one party purports to terminate before the other party has totally breached, then the terminating party is actually the one in breach and has done what is called a repudiation. Finally, courts may, in some cases, excuse performance, such that non-performance of an obligation is not a breach where performance would be impracticable or where the performance is frustrated.